It's a good idea for human resource professionals to be aware of the important court decisions that end up changing the landscape of Canadian employment law. Jeffrey Smith, the editor of Canadian HR Reporter's sister publication, Canadian Employment Law Today, recently highlighted some of the important cases from 2013. Here are some of those cases he says employers and HR must know about.
Now, the first case we should look at came out early in the year. It was the Ontario Nurses Association versus the London Health Sciences Centre. This was a case regarding a nurse in London, Ontario, who stole narcotics for her personal use several times over the course of a year. Now, as it turned out, the nurse suffered from addiction since the age of 12. And though she was fired, the arbitrator found that her misconduct was causally connected to her addiction, and an addiction is considered a disability. Now, in other cases without an addiction, the arbitrator did note that the misconduct would warrant just cause for dismissal for other employers, but in this case the nurse had the addiction, she participated in treatment and submitted to regular testing, and as a result the employer had a duty to accommodate, and in this case it didn't prove that it had accommodated to the point of undue hardship, despite the fact that the arbitrator called this misconduct going to the heart of what was reasonably expected of her as a nurse. So basically the moral of this story was, where disability is involved, employers have a duty to investigate every accommodation option to the point of undue hardship. The next case that came early in 2013 was one that dealt with the contentious issue of family status. This was Johnstone versus the Canada Border Services Agency. Now in this case, the Border Services Agency employee worked rotating shifts, and her husband also was an employee of the agency and also worked rotating shifts. And she had some young children, and their childcare needs didn't mesh with the shift schedule. So the employee requested 3 13-hour fixed shifts per week instead of a full-time week. The Border Services Agency offered her 34 hours per week instead, but as a constant shift. However, these were part-time hours, and both the Human Rights Tribunal and the federal court ruled that this was discrimination based on the employee's family status. Though there were previous cases that had different thresholds for discrimination based on family status, in this case, family status did not have a higher threshold for discrimination, according to the court. So basically it came down to that parental child care duties are included in the definition of family status, and the court pushed a broad interpretation of family status for this reason. An interesting case came down dealing with health and safety in Ontario that was in the news, dealt with the Blue Mountain Resort in Collingwood, Ontario. Their case name was Blue Mountain Resorts Limited versus Bach, and this stemmed from the drowning of a resort guest in the swimming pool where there was no employees present. Now, an Ontario Ministry of Labour inspector found that the pool was a workplace because employees occasionally worked there performing maintenance. And the Ontario Labour Relations Board and a court upheld this order to report the death to the Ministry of Labour, finding that a person, as defined in the health and safety legislation, meant that both workers and non-workers and workplace were all areas in or near where workers perform work. Now, the Ontario Court of Appeal overturned this decision, finding that that broad interpretation could make almost every place a workplace and make any death or injury reportable to the Ministry of Labour. The court ruled that there must be a reasonable nexus between the hazard giving rise to the death or injury and a realistic risk to worker safety at that workplace. So while initially this case gave employers pause for thought, in the end result they breathed a sigh of relief from this final kind of common sense decision. Now, over the past few years, there's been some class action lawsuits filed against some banks and financial institutions dealing with certain employment standards issues. Now, two particular cases, called Fulaka versus Bank of Nova Scotia and Fresco versus Canadian Imperial Bank of Commerce, dealt with unpaid overtime claims by large groups of employees against the two banks. Now, this went to the Supreme Court of Canada, and it was a case where both CIBC and Scotiabank had employees perform unapproved overtime without pay. The employees alleged that overtime policies of the banks conflicted with employment standards, and the banks used the justification that employees were required for pre-approval for overtime, and without that approval they could avoid paying overtime to the employees. Now, there's no decision yet, but the Supreme Court did approve these for class action to proceed, meaning there was a common thread between all the employees' claims, and the Supreme Court also noted this was an issue of public importance. So we'll have to keep our eyes out for the results of these class action suits.
Be sure to keep up to date about the latest developments in Canadian employment law by clicking on the Employment Law Today button near the top of Canadian HR Reporter's site, or visit www.employmentlawtoday.com.